media platforms and they say that the information we are going to release is the climax of all things. And the government of the state actually, on that same very day, decide to invite county government officials as well as cabinet. Remember?
But other than the bad blood between the government and the hierarchy, do you have any evidence to attribute the death? Because you have talked about two elements. One, the enforced disappearance.
Yes.
The colleague has asked you whether or not your paper is over. You say no. We have asked you, can you actually link and say that government officials, these people in the custody of government officials, say no. We have moved on to the initial killings. There was a car that was used, there were masked men. Can you attribute the masked men or the car to government? The answer is still no. But you are trying to show that there was bad blood between these people.
And
the hierarchy officials were not the only one invited for the meeting. There were other companies. So it can be anyone. Even a jilted lover for one of the officials, and the other for just collateral damage.
most of life, if I may take you back to paragraph 7, and with relation to paragraph 23 and 24 of the fact sheet, NAMRI actually calls out to the government and says, rehabilitate the water, it is so polluted. The government, being it was not enthusiastic, being compliant, never replied. But when the officials, that same very day, they did not even let the sun set. When the officials say that we are about to release information, the government becomes enthusiastic and they invite county government and companies. And you might wonder, why did they have to invite only 5 to the high officials?
How many do you want to be invited?
From paragraph 3 of the fact sheet, in the beginning there were 10 officials. And now they only invite the ones who are actually about to release a report. It is very fishy, if I may say this.
So you have preferred 10 to let it be die than rather 5.
Most of life.
That's what you're saying.
No, that is not our submission as the applicant. We are saying that.
So you have a minute to talking about.
We are saying that.
So if this one was
yes, you see most of life. That if I may revert to the same point, the fact is that we cannot dwell on the could-haves. We are dwelling on what has happened. And what has happened is the government was compliant. They were not willing to rehabilitate the water. They are not willing to care for the rights of the people of nature. And now that someone is about to release a report, in paragraph 38, the officials were about to compile the report when they were intercepted. We are saying that the government is responsible. And it is not only responsible, the government had assumed.
Also, just because the government reacted and said, we are very responsive government, we have been responsive in the past, we are now responsive. Please come, let's sit down. Now you want to blame them even for extending an olive branch and saying, there's something suspicious.
Yes, there is something suspicious. An NGO composed of more than 5 people, but they only invite 5 people. These 5 people accept the invitation and they go, and they were being trained. From my understanding, training means from behind, from where they were coming from, and they were coming from the meeting.
What do you mean you're being trained?
They were being trained from paragraph 38 that we are told that, unaware that they were being trained, the vehicles they drove across the border.
Well, they were being trained after the meeting.
Yes.
But not before.
Not before.
So
after the meeting, which had actually been facilitated by the respondent. So we claim that from where they were coming from, I understand that my time is running and I would like to seek the ground to the court. But we pray to this honorable court that since we have not been able to pray for an order of habeas corpus, noting that orders of the court and they are specific and enforceable, we pray that this court gives direction to the National Police Service of Nature as well as the respondents that they should conduct prompt, effective, and professional investigations with regard to the enforced disappearance in this case.
Thank you so much, my lord. Good morning, my lords and my ladies. My name is Obaka Bido, as I was introduced. Before this honorable court, I'll be handling on the issue of the right to highest attainable standard of health, clean and safe water, and on the issue of the right to clean and healthy environment. I will wish to proceed on the issue of the right to highest attainable standard of health and the right to clean and safe water. In that, I will first demonstrate before this honorable court the violations. First and foremost, it is our submission as the applicants that the respondents indeed and undeniably violated Article 43(1)(a) and 1(b) of Constitution of Nature 2010, which provides for the right to highest health, highest attainable standard of health and clean water, respectively. In the case of Anarita Karimi Njeru versus the AG and two others of the year 1979, a case which was relied and quoted in the case of Trusted Society of Human Rights Alliance versus AG 2013 EKLR, persuasive before this honorable court, it was stated that it established the principle that in matters concerning violations of human rights, the petitioner must plead with particularity and demonstrate before the court how exactly, and that is what I'm going to do before this honorable court, how exactly the respondents violated. Paragraph 14 of the fact pattern says that there are increased reported cases of lung cancer and black lung disease. It is our submission as the applicants that in this, it is very sad and hurting. This is not any other disease. This is not headache. This is cancer, and in particular, lung cancer. According to the World Health Organization report of 2018 on cancer, cancer has become world's deadliest, world's most chronic, and the most expensive to combat. And the question then shall be before this honorable court, do these people truly deserve that in the name of development? I will proceed to paragraph 19 of the fact pattern, paragraph 23 of the fact pattern, I'm sorry my lords and my ladies. Paragraph 23 of the fact pattern says that the report by Namri was so clear that the waters, the surrounding waters were polluted and contaminated, and the report recommended that that water is unfit for consumption. This clearly demonstrates before this honorable court that the right to clean and safe water has been grossly violated. Under article, I will proceed further. Under article 20, under paragraph 25 of the fact pattern, we can see that the mortality rate of the...
I'm sorry, I see you're trying to line now, but I have a question. I will take you away from your line back. I understand that Tendahati has been given. What does that mean for your daughter before the court?
Most obliged. During this time. However, under Article 22 of the Constitution of Nature 2010, it talks about people who can enforce the rights and fundamental, who can bring the violations.
If it's deregistered, will it still be a person recognized by law?
Most obliged. I would like to refer this honorable court to the case of MRC versus AG and others before the Court of Appeal, therefore binding before this honorable court, the year 2016. Most obliged, I'm ready for 1 minute.
You have
5 minutes. Yes. Most obliged. Thank you for the generosity. I will proceed before this honorable court. Before this honorable court, that this was not progressively achieved, but rather progressively. In the case of MMM versus AG and two others, Justice 2013 EKLR, persuasive before this honorable court, Justice Isaac Lenaola in that case stated in clear terms that when the state will wish to adopt a retrogressive measure, the state must demonstrate that that retrogressive measure has been adopted after careful consideration of all the options and impact assessment. I will proceed to the fact pattern and demonstrate before this honorable court that the careful consideration that was addressed by Justice Isaac Lenaola is lacking in this circumstance. Looking at paragraph 26 of the fact pattern, we can see that the World Health Organization and UNEP report stating that it is wondering why the government is investing in wind power and clean energy, but at the same time spending working overtime. Therefore, we can clearly see that at least the government or the state of nature has an option. Paragraph 20, looking at paragraph 19 of the fact pattern, we can see that the Cabinet Secretary for Legal Affairs considered that much more needed to be done. It is our submission as the applicants that if careful consideration of all the options were put into place, that this much more that needed to be done ought to have been done. It is our submission again before the Honorable Court.
Council, you have submitted that the government did not conduct an environmental impact assessment test. Can you please pinpoint the exact paragraph in the compromise that says this test was not done?
Most obliged. Thank you so much. It is my submission that there is no any unambiguous statement, any unequivocal statement from the fact pattern from paragraph 1 to 43 that the government conducted an environment impact assessment study. Any unambiguous. That is our submission, and therefore we rely on cogent evidences before this honorable court.
But Council, you are aware that the only thing you're claiming that the government used its influence to obtain all necessary permits and consents and authorizations. As you are well aware, the process of starting a massive environmental project such as the coal mining, you will need the environmental impact assessment test. Isn't it? Yes. Done by your National Environmental Management Authority. So they obtained it. What you should be questioning is not whether or not they obtained it, but that they did not follow whatever environmental impact assessment test that was done, because it's part and parcel of the permits and the consents you obtain before you start a project.
The question should actually not be a question of an EIA not having been done, but what we call an environmental. Have you followed up on the environmental?
Most obliged, my lord, my lady. It is our submission that on the issue of environment audit, it is the duty and obligation of the state and the owners of the company to be conducting.
But Article 69, 70 of the Constitution of this country gives the responsibility, the obligation to protect the environment, not only of the state but of every other person. Why wouldn't you then proceed to ensure that the environmental audit has been followed?
Most obliged. I understand, my lady, that is why we are before this honorable court. We are following up with the prejudices, injustices, and infringement of rights that have been.
Yes.
The name of the revoked of council of that.
The National Environmental Management Authority should have made that application so that they revoke the coal mining license, because the audit has not been carried out after every 3 to 6 months.
Most obliged, my lord, my lady. Looking at the closely looking and analyzing the case before this honorable court, it concerns matters of violations of human rights, which are socio-economic rights, which arise from violations by the state.
From coal mining.
From coal mining.
Yes.
Thank you so much, my lord.
The contamination of the water, the deaths you have attributed as a result of the cancer deaths, all arise from where? The coal mining. The poor working conditions of the coal miners arise from where? The coal mining. So why not apply to NEMA to revoke the license and just solve everything?
Most obliged, my lord. I'd like to refer this honorable court to paragraph 23. Regarding the coal polluting the waters, the report by NAMRI recommended that the government should rehabilitate the waters and that the company should invest.
Yes, the polluter pays principle says the polluter.
Yes. However, in this circumstance, thank you so much, my lady, in this circumstance, the government did not respond. So we did not have faith in the government's.
Are you praying that we make a declaration that the government rehabilitates the water?
We prayed for, in general, that is our prayer, my lady, in general, that the government declares and makes a declaration before this honorable court that they have not only violated the article of socio-economic rights, but also the right to clean and safety environment.
So the right to environment to proceed is the socio-economic rights. Which one is above the other?
Most obliged, my lady, there is no superior rights above the other. All rights
so how
are
do
equal.
we ensure that the government balances all these rights?
Most obliged. I would like to refer this honorable court to the Oposa versus Factoran case of 1993. This case was decided before the Supreme Court of Philippines, and this case has been praised for its contribution in the growth of international environmental law. In that case, the judge stated, I understand that you finish your statement. I'll finish my statement. In that case, the court stated that in any development project, the government must ensure its sustainability and put into consideration the health of the people around and the environment. Therefore, I proceed to state that the balance is on the sustainability, and in this particular circumstance, the sustainability is lacking, and that's our submission. Should I pray or?
Thank you. We are considering your prayer and your submission.
Thank you so much, madam.
The first answer for
Good morning, my lords, and my ladies, and thank you for making our time to come listen to us. For the purpose of record, my name is Anyeke J. Amarachi, and appearing with me is my co-counsel, Mushina J. Nyeke. The issue before this honorable court is one of business and human rights. In the course of our response to the applicant, we intend to rely on the Constitution of Kenyatta 2010, statutes, various international instruments, case laws, and legal texts. We have seen Code 108. I am going to use 13 minutes of this honorable court's time to address the preliminary issues in jurisdiction, local standards, and the issue of enforced disappearance and extrajudicial killings. And my co-counsel should take 12 minutes to address the issue on Article 42 and Article 43 respectively.
And for your presentation, Dr. Please address us on Article 40, eminence remains significant. I'm saying in your presentations also address us on the issue of eminence remain and Article 40.
Thank you, Maggie. If the bench seeks no clarification on my part, first, jurisdiction.
But let me ask you, counsel. Is your submission this court as jurisdiction?
Thank you, Maggie. These courts do not have jurisdiction. Part 1 to the second.
You're opposing jurisdiction.
Thank you, my lord. Yes, we're opposing jurisdiction.
You should compare the preliminary jurisdiction.
Thank you, my lady. We didn't because of due to circumstances.
Okay, just explain now why you are objecting to the court's jurisdiction.
Thank you, my lord.
And then we have follow-up questions towards your objection.
Thank you, my lord. First, the reason as to why we contend jurisdiction is pursuant to the second issue on Article 42 that speaks to the environment. Article 165 of the Constitution of Kenyatta 2010 has provided the Environmental and Land Court explicit jurisdiction to listen to matters that have to do with the environment. And we're contending that because of the Supreme Court case of Republic versus Karisa Achiengo in 2015 at the Supreme Court, which is binding, whereby the Supreme Court held that each court has its jurisdiction, and that the other courts at the High Court, which has the same status for different jurisdictions, should not interfere in the jurisdiction of other courts, which is the issue here. Article 42 speaks to environment, and therefore this honorable court should not listen to this matter because of it does not have the jurisdiction to listen to the matter passed on to the second issue.
Counsel, let's assume for me that we agree with you, and you have said we should immediately down our tools. So we can make an oral ruling here and we will leave. So far as we agree with you that we should listen to it.
Thank you, my lord. Much obliged.
And you are aware of the jurisprudence where we need to down our tools immediately. We notice that we do not have jurisdiction, and let's say we agree with you, so we can leave. It's okay.
Thank you, my lord. It's not issue for you to leave.
Yes, but
in the unlikely circumstances that this court find that indeed it has jurisdiction.
So we are not talking about in the event that we agree with you on your objection to jurisdiction. So do you also accept that we down our tools immediately? And
thank you, my lord. You should not down your tools. Why? Because there are 3 issues in contempt. But we are debating jurisdiction. The court has jurisdiction, but it has jurisdiction pursuant to matters relating to Article 42, Article 69, and Article 70 respectively. So we cannot take all these issues to the environment and
But Council, part of the issues that are being claimed by the applicants is, for example, deaths as a result of the mining activities in the coal mining. So it's affiliated to an environmental issue, isn't it? People disappeared allegedly as a result of visiting the mine. So it surrounds also the environmental issue. You understand where I'm going? That all these issues you're saying are separate are actually issues that indirectly arise from the issue of the environment.
Most obliged, my lord. Yes, all these issues revolve around the environment. But we should not refer this case, or rather the whole case, the whole issue, to the environment and land court, because it only has explicit jurisdiction on matters to do with Article 42, Article 69, and Article 70 respectively.
Article 42 falls within chapter 4 is on
Thank you, my lady. Yes, it falls under Chapter 4 of the Constitution that speaks to the Bill of Rights. But the other issues do not fall under Article 42. Yes, my lady. Sorry, thank you, my lady. Yes, it falls within Chapter 4, which speaks to the Bill of Rights. But
that which is within the limit of passport.
yes, my lady. Thank you.
Before you proceed, I understand that the challenge to jurisdiction is on the basis that there are certain matters within the petition that ought to be heard and determined in the environmental environment. Is that what I get?
Yes, my lord.
Very well. Now, and your understanding of Article 165 is that anything to do with environment is for the environment and land court. Anything, whatever it is. That's your understanding?
Yes.
Very well. How are you able to distinguish that with Article 165 3B, 165 3B, which gives the High Court jurisdiction to determine the question of whether a right of fundamental freedom in the Bill of Rights has been breached, without limiting anything, and that is where issues of breach of fundamental rights rest.
Thank you. Inasmuch as the Constitution provides that, this same Constitution provides in Article 162 clause 5 that states, in Article 162 clause 2, that states the Parliament shall enact courts of the same level with the High Court to determine matters as regards to the environment, and which Parliament have. And that's where we have the environment and land court at the same level with the High Court.
So what you're saying is that the Act of Parliament has taken away this power of this court to hear and determine issues to do with the breach of fundamental rights.
Thank you, my lord. It has, but as long as it has established the court that falls within the same statute, the same status as the High Court. So matters that have to do with the environment should be referred to the Environment and Land Court.
But Council, also to add on my colleague's clarification, if you think it will be counterproductive for us to determine some aspects, and then also the Environment and Land Court, and our colleagues also to determine some other aspects, why can't you allow this one court to listen and determine all the issues connected, including this Constitutional and Human Rights Division, which it has powers to do so?
Thank you, my lord. Jurisdiction should be left at the discretion of the honorable. So therefore, if this court finds that it has jurisdiction to hear and determine this matter, then it's at the discretion of the court.
Okay, so you are going to submit on locus?
Yes.
Do you oppose that they have a right to appear?
We oppose that they do not have the right to appear before this court. Because, thank you, my lord, the standard was to find in the case of Jurisdictional African Adventure Limited versus Charles Michael Lockwood, a 2017 case as a High Court which is persuasive, as the right to institute proceedings before the court. However, their applicants do not have the local standard to institute these proceedings because they do not fall within the ambit of Article 22 of the Constitution of India 2010 respectively, because they are suing under the name of Tendahaki, whereby Tendahaki has been deregistered. It is an entity that does not exist. So why then should they institute these proceedings under Tendahaki? My lord, and my ladies, the applicant do not have jurisdiction.
So, counsel, is it your submission by virtue of Article 22 that the applicants are not a person under the law because they were deregistered?
Yes, ma'am.
Then, counsel, how do you reconcile that with Article 260, which defines who a person is, including a company, association, or other body of persons, whether incorporated or unincorporated? And should we define a deregistered entity as an unincorporated person under the law? And therefore, they fit the meaning of a person under Article 260, and therefore they can enforce the Bill of Rights under Article 22.
Thank you, my lord, and what can I ask? For an organization to be recognized, it has to have legal status, which Tendahaki do not have.
But the Constitution, I've just read you Article 260, counsel.
Thank you.
Article 260 says it does not matter, so long as you're enforcing the Bill of Rights, whether or not you are registered or unregistered, you can represent a class of people to sue on the enforcement of the Bill of Rights.
Thank you, my lord, for that question. The applicants, I still stand on the ground. They don't have to understand. If they had
So, are you a professor of law?
Thank you, my lord. I am not a professor.
Are you a highly qualified publicist?
No, my lord.
Are you superior to the Constitution?
No, my lord.
So you want us to take your word over Article 260 of the Constitution?
No, my lord.
And it's very express. Or you have a different alternative interpretation of deregistration vis-a-vis an unincorporated entity that you want this court to listen to?
Thank you, my lord. I'm going to answer your question based on the applicant. The applicant is rejected because they failed to comply with tax laws.
No, counsel, it is fact, not in dispute, that the applicants, they have even admitted they were deregistered as a fact. But you are saying the deregistration, reading Article 22 and 260 harmoniously together, allows them to file a petition to enforce the Bill of Rights, whether or not they are registered. It is irrelevant that they are registered or not. That's what Article 260 says. So do you have an alternative article or provision of law other than the facts that you're taking us to?
Thank you, my lord. I rely on the PBO Act, that is the Public Benefit Organization, number 18 of 2013, in section 18, that states that whereby an organization certificate has been cancelled, it is an offense for that organization to bring proceedings before the court. And in this matter, they
so
have...
counsel, you are again citing a statute, and you want this court to uphold a provision of the statute over and above an express, clear, and ambiguous provision of the Constitution.
Thank you, my lord. It is the Constitution, but we should interpret this Constitution.
But counsel, you have not provided an alternative provision inside the Constitution itself that says that if you are deregistered, or you are unincorporated, you cannot enforce the Bill of Rights. And we are telling you, you are right in as far as civil matters are concerned. You are not a person under the law. But when it comes to the enforcement of Chapter 4, the Bill of Rights, it is irrelevant whether or not you are registered.
Yes, Council, I have a question that may end all this debate. Let's say Kenyatta wanted to approach court, challenge the registration. How would they then do it? Let's assume Kenyatta wanted to approach court to challenge the registration. How would they do it?
Thank you, my lord, for that question. Kenyatta, knowing that they have been registered, first would have come to court and said that, you see, the company has been deregistered due to certain
How would they approach court? They are according to you, they are non-existent in fact. They are more better than anything else. They don't exist. How would they approach court?
Thank you, my lord. They should have approached court through judicial on their registration.
But they can approach court in their own capacity as they have. Can they?
Thank you, my lord, and my lords and my ladies. I will concede to the fact that indeed the applicant have the local standard.
You should have said that a long time. Proceed.
Yes. Now moving on to my next argument on enforce the parents and extradition. We, as the respondent, deny all allegations that we do not have a hand in the enforce the parent or extradition case of the Kenyatta. My lords and my ladies, the elements of enforced appearance are that there should be deprivation of the rights of these individuals. We are not contending, yes, there have been deprivation of the rights of these individuals under Article 29 of the Constitution. But on the second element that speaks to that this enforced appearance should be effected by the state.
And what would be your justification for the deprivation of some rights?
Pardon my lady?
What then are your justifications? You agree that there has been deprivation of rights. What is your justification?
Thank you, my lady. The applicant has said that the state had a hand, but the state does not have a hand because they haven't established this on the balance of probability. And
have you described any rights on the part of the petition?
Thank you, my lady. We haven't. Because the applicant is supposed to prove their case pursuant to Section 109 of the Evidence Act of 80 that speaks to people alleges must prove. The applicant haven't proved their case that indeed the respondent had a hand in the enforcement. The witnesses that were there said that these men were marked. What is the nexus between marksmen and the respondent?
But also, relying on similar facts, there has been a series of brutal victims by police. Yeah, if a police has beaten someone, day one, they have beaten someone, there's another incident, a third incident. Now, in the fourth incident, the persons are unknown. A reasonable conclusion can be drawn that it is still the police who are beating up people.
Thank you, my lady. Those individuals will serve a disciplinary action. Because in as much as we are the state, we do not like the fact that we see bad things and turn blind eyes to bad things.
So you are submitting that they are wrong policemen who have done that?
The policemen shall be sanctioned because of their actions.
Are you admitting that it is the police who have actually led to the enforced disappearances of these people?
No, my lady. Because we deny that we do not have a hand. Because the applicant cannot prove the nexus between us and the marksmen. The fact that the Kenyatta officials were coming out of the meeting, it can be anyone, any news of the state. My lords and my ladies, they do not have to.
Has the state investigated these claims?
Thank you. If we look at paragraph 41 of the fact sheet, it's shown that the state, or rather the police, has made inquiries. Inquiries, my lord, is a step.
You understand inquiries and investigations are two different terminologies, right?
Yes.
And the responsibility of the state through its security mechanisms has the obligation to investigate in line with safeguarding these rights. So has the state carried out investigations? Because one of the claims, if I tend to hear right, is that the state has refused to carry out investigations, and the applicant is seeking to compel the state to investigate.
Thank you, my lord. Even the applicants themselves said that the process is still under investigation. And investigation do not have limitation of time, but it should be the same, which the respondents have. The journey of 1,000 miles, my lord, starts with a step, and that is what the applicant needs to understand. That making inquiries is a process to investigation.
And you still need more time to investigate.
Thank you, my lord. Yes, you still need more time because
Justice delayed is justice.
yes, my lady, justice delayed is justice denied. But we are taking reasonable steps to make sure that these assets are apprehended.
And so lastly, how long do you need to finish the investigation? How long do you need?
How long we need to finish the investigation?
Yes.
Reasonable time.
Which is
Which we can say 20 days.
20 days.
Yes.
In less than a month, you'll have finished the investigation.
Yes.
Thank you, Council, for your submission.
You've just committed on behalf of the state.
Thank you, Council. The second Council, please address the court.
Good morning, my lords and my ladies. As already introduced by my co-counsel, Anete J. Amarachi, my name is Mshina J. Nyeda, counsel appearing for the respondent in this suit, and I'll be submitting on issue A on violation of Article 43 and issue B on violation of Article 43.
Do you come from the Attorney General's office?
Thank you very much, my lady. I am representing the state and I come from the Attorney General's office. Thank you very much for your question. It has come to our attention that time is not on our side, and I take this honorable court to add me at least 3 extra minutes to make my submissions.
You still have time. Why are you asking?
Yes.
You might not get it.
Thank you very much. What I meant is time has we have raised
The time that you're speaking would be
use the time you have. If it ends, you will add.
Thank you very much, my lords. Thank you very much. In my submission, I would like to state this: that when suffering comes knocking at one's door, and you tell it that no, I have no seat for you, it will tell you, don't worry, I came with my history. These were the words of Chinwati. My lords and my ladies, in this suit, the state of nature has suffered.
So, Council, who is Chinwati?
Thank you very much, my lord. I understand that the court has
He a
no
judge.
Thank you very much.
He or she a judge.
Thank you very much, my lord.
Was that a legal decision? Was that a book?
It is something that we can take judicial
Thank you very much, my lord. Thank you very much for your.
What do you want us to do with that code?
Thank you very much, madam, for your interjection. I'd like to state that the court has no legal binding. It has no legal binding effect on this court. It was only made in the process of showing how serious we are taking this matter brought forth by the.
By citing a literature book, but proceed, Council. I thought you start with a quote from another brother or sister of ours in another bench, but please proceed.
Thank you very much, my lord. Article 43 of the Constitution of Nigeria, it provides very clearly that the state has an obligation, pardon my lord, that every person has the right to the highest attainable standard of health. And Article 43(1) provides that every person has the right to access water and safe and adequate quantity. These are submission of the state.
Council, please, with the time remaining, give the reasons why you are submitting or alleging that the right to health has been violated. The reasons why.
I beg your pardon, my lord.
I'm saying with the time remaining, give the reasons why you are submitting or alleging submitting that the right to health was violated.
Thank you very much, my lord. That's the
Reasons why. Yes. Don't go to a process, just give the reasons why and explain where you can.
Are you saying it was violated or not?
Thank you very much, my lord. I was say I was only highlighting the provision of the article, not considering that it has been violated.
Okay, so why was it not violated?
Thank you very much.
Give those reasons.
If I may invite this honorable court to read through paragraph 14 of the fact pattern, paragraph 26 of the fact pattern, and paragraph 22 of the fact pattern. This particular paragraph, they show that the state has followed Article 21.2 of the Constitution of Nature, which shed light on Article 43. Article 21.2 states that the state shall come up with legislative measures and setting of standards for the progressive realization of socio-economic rights. The term progressive realization was defined in the case of Magi Okwanda versus the Minister of Health in the year 2013 before the High Court of Nature, a case that is persuasive to this honorable court. They stated this, that progressive realization means the state must be seen to take steps for the achievement of this right. This is what I am submitting to this honorable court.
What is the court then doing to advance climate change?
Thank you very much, my lord, my lady. Even if you may allow for me to answer your question in the submission of violation, non-violation of the environment.
Respond to her question. Don't refer.
Thank you very much. I stand guided by this court. Violation of Article 42. The state, in protecting this right, have signed it. Thank you very much, my lord. The state, in protecting the right to the environment, has signed the Paris Climate Accord of 2015. The Paris Climate Accord of 2015, under Article 4, allows the state that are developing more time to move from non-renewable sources of energy to renewable sources of energy. These are submissions existing by the
Coal mining renewable.
It is non-renewable by virtue of the Mining Act, the first schedule. Thank you very much.
And don't you pursue other forms of renewable clean energy before you resorted to court?
Thank you very much, my lord. It is my submission that paragraph 27 of the first part shows very clearly that the state has actually pursued renewable sources of energy. And in this case, it is wind power, which is a renewable source of energy. Going to show that the state has actually tried and taken steps to protect the right to a clean and safe environment. If I may proceed.
But Council, under paragraph 27, you're saying that the result of the coal mining, despite its bad effects, you're going to proceed on. Is that the case?
Yes, my lady. My legal apology and my investigated report. The actual paragraph is paragraph 25 and 26. Where you have the report.
I still retain the question. You're going to proceed on despite the bad effects of the coal mining.
Thank you very much. In that very same paragraph, paragraph 27, if you move to the lower part, the parliament stated this, that they have directed the ministry in charge of industrialization to oversee the betterment of the people of the lives of the people of Lindi. Going to show that it is the state position that they are trying and they are going to work to help the people of Lindi to move from the position
So
they
the
are at
end
the moment.
justifies the means.
Pardon, my lady.
The end justifies the means that you're using. Is that what you're saying?
Thank you very much, my lady. That is not what I mean. I would like to invoke general comment number 2 on the socio-economic and cultural rights, which says that this, that in achieving progressive realization of socio-economic rights, the state shall rely on the available resources as a movement. As a developing state of nature, we are using what we can for the time being. But in this, we are still realizing the right progressively, despite all the facts. If I may proceed.
Now, before you proceed, are you saying that there have been no complaints and allegations of interference with the environment as it is because of the
Thank you very much, my fair question. We are not stating that there is not vote. There are.
very well? Do you confirm that there are allegations that there are certain diseases that have come as a consequence of these issues, including lung cancer?
Thank you very much, my lord. And in answering that question, I'd like to refer to paragraph 16 of the fact pattern, where it says that the medical researchers who looked into this matter, their report was not conclusive to tie the.
But there are allegations.
But there are allegations.
So what has the state then done to confirm that these reports are either true or untrue.
Thank you very much, my lord. Invite by direct this honorable report to paragraph 27 of the first part, where these reports have been discussed in Parliament. And after discussion in Parliament, they have ordered the ministry in charge of industrialization to go to Lily and fix the problems that are there.
Meaning the discussions have actually confirmed that these things are happening.
The discussions have confirmed that things are happening, but they have not confirmed that these things can be tied.
No, but forget where it can be tied. The issue is whether they are true. They are happening.
Yes, my lord, these things are happening in Lily, which is a sad state in Lily.
Very well. Now, then what is the state now telling us, coming before the court to tell us that the right to environment has not been breached? You stood there, you said when my colleague asked you to explain why you're saying it has been breached, you said, no, I'm not saying it has been breached. As a matter of fact, I'm saying it has not been breached. So what does that tell us about the seriousness the state is taking about this matter?
Thank you very much, my lord. Before I answer the question, I'd like to ask for an extra 1 minute.
No, just answer the question. Can you stop asking for time?
Thank you very much. Thank you very much. In answering your question, I will refer to Article 69 and Article 42. Article 42 makes it very clear that the right to an environment shall be achieved through Article 69 of the Constitution of Nature. Article 69 provides for the ways in which the environment shall be protected. And one of these ways is the utilization of the environment for the protection, for the benefit of the people of nature. And that is why they're using the environment to mine coal. And once again, still on the same point, there is what you call the best way to achieve this is sustainability, which is what the state is doing. Sustainability development.
As you wind up the next session, what my colleague has been bringing up to you is that one, you have told us that you intend to argue the right to health. The environment has not been breached, but at the same time, you can recognize the fact that Parliament said that there were health hazards that in some kind of an industry that was expected. And there's a problem there on health, there's a crisis, people are dying, something should be done by the means of industrialization. So you are double speaking at the same time of the state.
Thank you very much.
What is your position? That something wrong has happened and you intend to cure it, or nothing wrong has happened? There was actually no violation. Health is good, people are healthy, the environment is not polluted, things are okay. What is your position?
Thank you very much.
Be specific about it.
Thank you very much. It is understand that the facts of the case are not in our favor, which is very true. However, my lord, the right to environment is being achieved through Article 69.
But it's also just answer the question I'm asking you. Stop resubmitting.
Thank you very much.
People are dying. People have contracted cancer. Water has been polluted. Has the right to health been violated or not? Considering you're even in your own parliament accepted, you say something went wrong.
Thank you very much, my lord. Yes, the right have been violated.
Thank you, Council. Thank you for your submissions.
Thank you very much. You maintain our prayers and they are stated in the documents. Thank you very much.
In cases of violation of human rights, the state cannot come in to say that the burden has not been discharged, because we as the applicants also require the support and the cooperation of the state in these investigations. And I say that pursuant to Article 243 of the Constitution of Nature, that the police are trained professionally to the highest standards possible, and they cannot come to court to actually say that they only conducted mere inquiries which do not lead to the establishment of the relevant facts. Thank you. We rest our case.
As the presiding judge, I get your sense and discretion. I give you 30 seconds for Sir Rebuttal to say something directly raised in her rebuttal, not what you did not say. Do you want to exercise that, or you want to dispense with it? You say something. 30 seconds counting from now.
The applicant needs to understand that in this life, everything is procedural, and the state on its part, it's making sure that investigations are being conducted. So the applicant should not say that the states are not conducting investigations. Thank you.
Thank you. The court will take this opportunity to thank counsels for the applicants and counsel for the respondents for your able submissions. We will retire to our chambers and reserve the judgment for the next few hours. It will be communicated by the clerks and the bailiffs. For now, the matter stands adjourned. You can leave at your own pleasure. Thank you very much.
All right. Counsels, you're proceeding to the new moot court in session block for your second round.
I'll take this opportunity to welcome counsels for the applicant, petitioner, and counsels for the respondent to eventually introduce themselves from my extreme left to right.
Good morning, counsel. My name is Kenya.
Good morning. My name is Kenyatta.
Good morning. My name is rebuttal.
And I am Nasanda Aki.
And I am Mugabe Mugambi, presiding. The first counsel for the applicant petitioner, please address the court.
May it please this court. Pardon me. Mr. President, Your Honors, may it please this court, my name is Rachel Mendra, appearing as counsel for the applicant. Along with me is my co-counsel Margaret Mutinda. Together we will be addressing this court on the merits of our claim. Without any further questions, we beg to proceed and discuss
There were no questions previously, so they can't be further questions, but proceed.
Thank you, Mr. President. Concerning jurisdiction, the applicant submits that this court has jurisdiction to listen, hear, and determine on this matter. Pursuant to Article 23 of the Constitution.
Before you begin, you could just tell us what you're going to present on delving into each item.
Pardon my mistake, Your Honor. I will address this court on the preliminary issues as well as issue 1, and my co-counsel will address this court on issue 2 concerning environmental rights and issue 3 concerning enforced disappearance, as well as our prayers before this court. I will take 10 minutes to address this court, and my co-counsel will take 15 minutes. Mr. President, Your Honors, it is our submission that this court has jurisdiction to hear and determine on this matter as provided for under Article 23 as well as Article 165 Article 3 that provides that this court has unlimited and original jurisdiction concerning the Bill of Rights. Furthermore, it is our submission that the merits of this claim are admissible and that we can seek redress before this court. Concerning the matter of local standard, it is our submission that we have standing before this court because we satisfy the criteria stipulated under the Constitution, under Article 22 as well as Article 258 of the Constitution, that every person has the right to institute court proceedings before this court. Furthermore, we submit that we are indeed registered. Paragraph 42 and 43 of the facts stipulate that we have received a deregistered notice. However, it is our submission that we received this deregistered notice on the 14th of January, and we have come before this court on the 28th of January, following the computation of time provided for under the Public Benefits Organization Act, which states that deregistration takes place 15 days after it is shown, following arithmetic precision that we have followed that.
Okay, so you're saying that before the deregistration has taken effect, during that period you still are a registered entity until the time elapses. So and you file this matter within that particular period. That's your submission?
Yes, that is our submission, Mr. President. Furthermore, without any further questions, we beg to proceed to our substantive argument.
Why would you have not taken rebuttal to the National Environment Tribunal?
Thank you for your excellent question, Your Honors. It is our submission that following the decision decided in Mohammed Ali Badi and others versus the Attorney General and others, decided before the High Court and hence persuasive, it was decided that in matters concerning, in cases with a hybrid nature, meaning that they have several issues, that the court ought to look at the substantial question. Here the substantial question is human rights, and the Environmental Land Court has jurisdiction to
What about the National Environment Tribunal? The question is, why did you, I mean, one of the issues you're raising is that environment.
Thank you. Our other issue is enforced disappearance, and the National Land Tribunal would not have jurisdiction concerning enforced disappearance, which concerns the right to deprive liberty as well as the right to life.
Do you understand this question? Would you like clarification?
I would like a clarification.
Very well. Now, in law, what happens is that you take the grievance, the court that is lowest, or the body that is at the lowest that will hear and determine the matter. Now you're raising issues to do with environmental concerns. And my colleague is asking that there is a tribunal specifically for that. Why then did you opt to come to the High Court and not go through the tribunal?
The applicant submits that other issues, environmental issues are not the only issues. There are other issues of enforced disappearance, and the National Land Tribunal would not have jurisdiction to hear and determine on this matter. Furthermore,
so are you saying if there were criminal issues, you would lump them together into this claim and bring them to the High Court under constitutional protection?
thank you for your question. In that case that I cited earlier, the Muhammad Ali al-Badi case, the learned justice stated the principle of res judicata, and that is one suit and one judgment at the same time. So from this case, we see the interdependent.
Well, that's what res judicata means.
It means, Your Honor, res judicata means that it should not be filed in various courts, and that is our submission.
What would sub judice mean?
Pardon?
What would sub judice mean?
The applicant submits that it has not espoused into that matter. However,
That's why it's not a matter, it's just a principle. So it's your other way of saying you don't know, but it's okay.
But beyond that question, maybe to take you back to the issue of where you said the registration has not taken effect. I'm sure we are not going to determine this matter today. So should we retire to consider your submissions and time lapses? Or what should happen when we come back? Will you still be in situ to receive the decision? Will now the registration have taken effect? What does that mean for us as a court?
thank you for your question, Your Honor. In responding to that question, I rely on the Mumo Matemo vs. Trusted Society of Human Rights Alliance that was decided before the Supreme Court of Kenya. And in that case, we saw similar facts happening to Trusted Society of Human Rights Alliance, which was originally registered, and then in the process it became deregistered during the court proceedings, and the court held that it did have standing before that court.
Why did it have standing according to the judges in that?
There were several reasons for why it had standing, and former Chief Justice William Mutunga said, paraphrasing what he said, was that the rules of locus standi have been baptized in the name of constitutionalism, and that the court, reiterating what was said in the Court of Appeal judgment by Justice Owoko, that anyone who is not a mere busybody or meddlesome interloper bringing a case in good faith has standing. It is our submission that we are not.
So do you agree that the argument goes beyond the computation of standing that you articulated so heavily?
obliged. It does go beyond. Furthermore, yes, it goes beyond submission. Without any further questions?
Also a question. Article 159 of the Constitution gives room for alternative dispute resolution in dispensation of justice. I refer you to paragraph 38 of the fact sheet, where the government is already in talks with the host community affected and other organizations with a bid to settle this issue, these cases of human rights violations out of court. Yet you have come to court. Is it that premature? Are you in court prematurely? Why don't you want to exhaust the alternative dispute resolutions before coming to court?
Thank you, my lady, for your question. It is our submission that after paragraph 38, the enforced disappearance of the tender haki officials occurred, and therefore alternative dispute resolution would not be the best mechanism to redress our claims.
So if we severe prayer 3, can we subject prayer 1 and 2 to alternative dispute resolution?
Will you be willing as a party to subject it to 1 and 2?
It is our submission that we would be unwilling to subject it to alternative dispute resolution, and we feel that this court is the best place to handle this matter.
On what basis? Why don't you want to subject this to alternative dispute resolution? And yet this is a company that has been set up. It's providing jobs for the host community members. When you come to court, we'll give a decision which will eventually result into a win-lose situation, and it will change the relations between a company that would still be operating there and the people there, in the interest of furthering the relations between the company and the host community members. I think alternative dispute resolution would be the best in the circumstances.
Much obliged, my lady. It is our submission that following the decision in the Matthew Opondo versus Minister of Health decided in 2013, that the courts are the best place to seek redress rather than alternative dispute resolution concerning human rights especially. If it was another matter, possibly. That is our submission. Your Honor, it is our submission. It is in addressing the first issue, I'll address it under two heads of argument. Firstly, that the respondents have violated the right to health, the highest attainable standard of health. Secondly, that the respondents have violated the right to water. On the right to the highest attainable standard of health, it is provided for under Article 43A of the Constitution of NATIA, as well as other relevant international instruments that NATIA is party to by virtue of Article 2 of the Constitution, that international law forms the body of the law of NATIA, and it is our submission that it has violated Article 16 of the African Charter on Human and People's Rights, as well as Article 11 and 12 of the International Convention on Economic, Social and Cultural Rights. They violated this right through coal mining. You can see from paragraph 25 to 30 of the facts how coal mining has led to increase in the mortality rate by 20%, as well as the increase in a decrease rather in the life expectancy. Therefore, we can, from the general comment of the United Nations, of the Committee on Economic, Social and Cultural Rights, we see that they have violated these people's right to dignity, as right to health is linked to dignity as well as health. Your Honor, it is our submission that the applicants have violated this right in several ways. Furthermore, we see that they have failed in the obligation to provide protective gear to the shown in paragraph 26 of the facts to the mine workers, and that.
So is that the correct position? Did they fail to provide the protective gear to the workers?
My lady, the World Health Organization as well as the UNEP report is the one that released this, and we are cognizant of the wording that states alleged and suggestions, and this is to prevent liability as liability on the part of the World Health Organization.
So, Council, they were given protective gears, but what they were not given is allegedly gears of a particular standard. Paragraph 6, isn't it? So your assertion that they were not given gears is wrong.
Mr. President, the applicant retracts on that statement. However, we submit alternatively that the standard of protective gear was not in order, and in the case of Nkala and others versus how many gold mining company decided in 2016 before the South African court, it was stated that when concerning protective gear, that the state has to ensure that it is to the required standard, and if not, and if workers contract any disease, then the state would be liable for that as well as the company.
So you want the state in this instance to be liable?
Indeed, because it is.
So what form of liability do you want to attribute to the state? So they got sick, the gears are not the request that they got sick. Then what next?
Thank you. That brings us to one of our prayers, which is that they compensate the workers who have contracted lung disease.
So how much do you want?
It is to be decided at a later stage.
Which later stage? And you just made that prayer. And by who decides at a later stage?
It is at the discretion of the courts, Mr. President.
We are the ones to decide, right?
Yes.
And we are here, we are asking you the questions to enable us to be able to decide.
So, number one, what authority can you use to say that in this instance where this person suffers from this as a result of liability attributed to this person, these are the parameters you use to arrive at this figure, and therefore, by virtue of this, adopt it and arrive at this figure that we're suggesting. Do you have any?
Yes, in the earlier mentioned case of Nkala and others versus Harmony Gold Mining Company, the company was required to compensate the workers approximately 350 million rands, and at this stage, the applicants submit that you would have to calculate as well as engage accountants in order to come up with the coal miners will be compensated by other parties. Furthermore, accountants are necessary as they are experts and they can help us arrive at the figure that we deserve.
Which is?
At this stage, it would not be proper to.
So you want us to make orders in vain?
In fact, what you're asking us is that we should abdicate the responsibility that you say we have to accountants to decide the figure that you are entitled to, your clients are entitled.
The applicant submits in view of the learned justice directions that we kindly request the court to award us 1 billion Kenyan shillings.
To how many people?
To the we will have to find the exact number of people who have been affected by lung cancer. And in paragraph 25 it says 2 out of 10. So mathematics.
You're saying there are multiple claims,
yes,
right? There are claims of people who are involved because of these issues that who be dispossessed to land, property, and myriad other issues. But you're saying this claim that this award that we give should only go to people with cancer. Have you understood your case, the facts of your case?
And to add on my colleague's question, now that we have people who have been displaced of their property, what parameters can we use to compensate them, being cognizant of the provision of the Constitution that requires prompt payment if the state invokes compulsory acquisition?
Thank you. Your Honor, it is our submission that the applicants are aware of our case. However, coming up
with the exact logistics that this venture would be a challenge for us. Furthermore, to address Mr.
Then why are you asking for it in the first place?
The applicant submits that concerning our damages, they should be that those who have contracted lung cancer and black lung disease, they should get the majority share of the compensation, which would be.
You know, you keep taking us back into we ignore it. And my question is, why would you ask for something that you yourself admit that you have not done proper research, you're not well back? Why not then stick to what is provided in your petition? The order for damages is new, isn't it?
The applicant submits that in several cases.
Isn't it? The order for damages is new, isn't it? Or is it in your petition?
You don't even know.
It is in our petition in prayer 1.
Which prayer number?
The first prayer. Yes. Yes. I beg to proceed to the second.
And also you have not addressed the issue of compulsory acquisition, the displacement of people from their property. Please address that.
Thank you. It is the applicant's submission that the displacement of Mr. Abdullahi that the state did not follow the appropriate measures, and in that case the appropriate measures was firstly giving them a notice, and secondly it ought to have that the state ought to have worked within the provisions of the Land Act. It is our submission that they should compensate them in full, that the
two-thirds are violating the provisions of the Land Act other than giving notice.
Yes, that there should also be a purpose for the acquisition of land, and it is our submission that the purpose in this case is not quite clear on the respondent side, as well as in the event that they have met the test. In case if this court deems to be
communicated that it's for expansion of the coal mining company, which is a public interest issue.
We concede on that issue.
Yes, please sit some ground.
Yes, I now take this time to invite my co-counsel to address this court on issue 2, issue 3, as well as our prayers before this court.
Between issue 2 and issue 3, counsel, please pick one that you strongly feel about so that we concentrate on that.
Okay, thank you, Mr. President, Your Honors. My name is Margaret Matinda, counsel for the applicant. I will address this court on issue 2. I'd also like an opportunity to address the court on her issue on compulsory acquisition, if the court allows. It is a submission that, according to Section 120 of the Land Act, that the state ought to compensate Mr. Abdullahi according to the market value of the land. Only this was 3/4 paid, and therefore it is a submission that this payment should be made in full. Therefore, also the payment was not promptly paid. We also pray for interest in this regard.
What amounts to adequate compensation?
Adequate compensation in terms of land, it is our submission, and according to the guidance of Section 120 of the Land Act, that the land should be compensated according to its market value at the moment.
But on the issue of being paid 3/4 of the value of the land, it is just a mere allegation of Mr.
It is a submission, my lady, that these allegations are true. Therefore, the court should look into it.
So we should take your word and your client's word that the allegations are true.
Also, Your Honor, there is evidence of force in evicting this residents from this place. We see that the police used force. They burnt down their houses, and they also threatened these people. Therefore, it is a submission, Your Honor, that this compensation was not made even in good faith. Therefore, we can't even trust that the payments were fully made. Thank you, Your Honor. May I proceed to my second issue? It is a submission that the respondent has failed in its duty to protect the genetic and the biodiversity in Lindi residency. We see that according to Article 69 of the Constitution, that the state has the duty to protect the genetic and the resources provided for in the state. Therefore, it is a submission that this court... Thank you, Mr. President. Therefore, it is a submission that at this stage, according to the case of Leach versus National Wildlife Reserve in Environment and Land Court, that it was stated where there is a threat of violation of biodiversity, that this act should be stopped, and where it has not been stopped, that the perpetrator should adequately compensate to restore this.
Did you just use the case of the Environment and Land Court?
Yes, Your Honor.
Taking you back to the issue, that case is similar, has similar issues. Why are these issues then being litigated there? So it fits to use their case.
Thank you, Your Honor, for your question. It is a submission that this will bring about the risk of res judicata, because the facts in issue here is coupled with other issues on public rights and criminality.
Counsel, we can just make an order for transfer of the matter to the ELC, and you can go there and canvass your issue. That's simply what you can pray for. If we granted, so that we dismiss the matter, we just transfer the matter.
Thank you.
Which other issues are you talking about? Are you talking about the issue of compulsory acquisition of land? Which is also a land issue?
No, on the first issue on economic and social rights, and also on the violation of the rights of life to the 3 members of Tenda Haki and enforced disappearance of the 2 other members of Tenda Haki.
Sorry, are these economic rights issues arising from the environmental
Indeed, Your Honor.
And to add on that, is there an express provision of law that you are aware of that prohibits the ELC from interpreting or enforcing any one of the rights in Chapter 4? Is there a provision? There is none, I'm assuming.
Yeah.
So yes, this matter can actually be adequately dealt with at the ELC.
However, this has not been expressly provided for in the law. Therefore, acting in matters that the law has not granted its jurisdiction in, it will have acted outside its jurisdiction.
Environment and Land Court Act.
Yes.
Have you seen the jurisdictional confines that are provided?
Yes.
Do you still say these issues are not provided?
Yes, Your Honor.
Counsel, you have not tried that. It's okay. Proceed.
If I may proceed to my second subhead, that the state has failed in ensuring sustainable exploitation of the environment by failure to apply precautionary principle. We see that according to Section 69 of the Constitution, sub-article A, where it has been provided for that, the state should ensure sustainable exploitation, utilization, and also under the same Article 69, it provides that the state should apply the precautionary principle. It is a submission that the test for precautionary principle is where there is a wide threat, even and the scientific report has not been conclusive yet, and therefore it is a submission that according to the case of Fadeyeva versus Russia, which is a European case of human rights in this matter, we shall apply the test which they applied in that matter, where they said that even if there is no causal link between the pollution and the and the illnesses. In assessing the evidence, they shall look if the evidence is concordant, if the evidence is strong and clear with similar and rebutted facts. It is a submission, Your Honor, according to paragraph 16, that the medical researchers are unanimous that that the act the coal mining industry is causing black lung cancer and cancer diseases, and this matter has been unanimously agreed upon by the medical researcher. Therefore, for lack of
so what then are the best practices in terms of disposal of waste and coal
in other jurisdictions such as Botswana, we see that coal mining takes place. However, the coal mines in the area use factors such as transforming the coal waste into stones. This protects the law by using this coal waste to make artifacts. That the law should not, that the coal waste should not be disposed into the water sources and pollute the water sources adjacent to the drinking.
Now that you have identified that, has the applicant taken measures to recommend the same to the state? And I can see in paragraph 24 you actually wrote a letter. Yes. So in that letter, were there those recommendations made?
It is a submission that indeed we made these recommendations. However, the nature coal mine industry ignored our request and therefore did not take any measures.
The only thing you highlighted in the letter was a question to the state on how they will change their waste dumping mechanism, not an approach on how they will do it.
The position. It is our submission that
we have the position that you actually you were asking a question on how.
Yes, it is a submission that we gave them a particular list on how they can do it, and we asked them in which regard they wish to undertake this measure.
You have 2 minutes. So before you sit down, I have one final question. I asked your colleague as to whether the prayer was new prayer in line with the people who are suffering from lung cancer caused by pollution. Your colleague gave me a negative answer saying that no, it was not a new prayer. I would like to raise the same question to you. Do you think it's a new prayer?
Thank you, Your Honor. In this regard, Your Honor, we would like to suggest to the court that it applies the Serak versus Nigeria case, where the Ogoni people, when they went to seek to seek compensation, the court suggested that in regards where damages, general damages are sought, that the court can apply.
This question is very clear. Did you plead that you want damages?
Yes, as our compensation.
Where is that?
In our prayers. In our prayers and article and prayer 1, prayer 2.
Please.
And prayer 3, whereby we prayed that the families would be compensated, that the mine workers would be compensated for the damages and also for their illnesses.
What about the landowner?
That matter was not before in the issues before this court.
But it's on the recent facts. It's a contentious issue of the government's action, and it relates to the coal mining, because the land was acquired compulsorily so that the coal mining can be expanded. And again, you come back to the issue of jurisdiction. Isn't it better suited the environmental land to handle other lands?
Indeed, Mr. President, we do acknowledge that issue. However, since it has not been raised in this matter, we will
just forget about it. Thank you, Council. Thank you for your submission. Will the first Council for the respondent please address the court?
We'll take note of this prayer.
May it please this honorable court, my name is Milligan Nyabucho, first counsel for the respondent. Appearing with my co-counsel.
Counsel, what if he doesn't please the court? Then what next?
Please restate your name before you answer.
Milligan Nyabucho.
Milligan?
Yes.
Okay.
Nyabucho, on my documents I see
Milligan Nyabucho.
So you prefer Kwamboka on paper and on pronunciation in that
From mine, since you prefer Nyabucho,
who are you?
It's Milligan Nyabucho and Kwamboka Milligan, you're the same person?
Yes.
Is there an affidavit that you get
As stated, my name is Milligan Kwamboka Nyabucho. Appearing with me is my co-counsel, Salaton Lemaya. We are appearing on behalf of the respondents, the first being Nature Coal Mining Company and the second being the Attorney General of the state of Nature. I will take the first 10 minutes to address issue 1, under which it is our submission that the respondents have not violated the rights of the residents of Lindy Town to the highest attainable standard.
So you accept and consider the fact that the court has jurisdiction?
Yes.
And the applicants have no case?
Yes.
Okay.
My co-counsel will take the next 15 minutes to address issue 2 and 3, under which it is our submission that the respondents have not violated the right to a general clean and satisfactory environment of the residents of Lindy. And under issue 3, under which we submit that the respondents should not be held liable for the enforced disappearance and killings of the 5 Tender-Hack officials. If there are no further directions, I wish to proceed to make my submissions. I will advance my submission on issue 1, that is the right to the highest attainable standard of health, based on 2 arguments. The first being the progressive realization of rights, and the second being that the government acted in good faith in line with the concept of due diligence. If there are no questions, I wish to make my substantive arguments. The progressive realization of rights, particularly the rights under Article 43, has been addressed in Article 21, to which says the government is to take legislative and other measures to ensure that the rights provided in Article 43 of the same Constitution are progressively realized. Again, the African Charter in Article 19 states clearly that all rights have equal standing. However, the same charter in Article 62 states that the states should provide periodic 2-year reports on legislative and other measures, including policy measures, that they are taking to ensure these rights provided by the Charter, that is including the right to health, which it provides under Article 24, has been achieved progressively. This has been expounded upon in page 44 and 45 of the second volume of the documents of the African Charter on Human and People Rights, which is a publication by the African Charter, which is 1982.
Yes, are you aware of Section 12 of the International Convention on Economic and Social and Cultural Rights? Would I be speaking?
It addresses the issue of progressive realization of rights.
And are you aware of the General Comment number 12?
Yes.
Interpreting the right to health. It speaks about the underlying determinants to health. Do you know the underlying determinants to health?
Thank you, Your Honor. To respond to your question, the underlying determinants to health, as far as I understand, it says that the right to health has to be enforced in a manner which ensures that the quality of life of these parties, the ones who are entitled to this right of health, is not undermined.
So let me help you. The underlying determinants to health include safe drinking water and adequate sanitation, safe food, healthy working environment, environmental conditions. Yeah. And you're saying that the state has not violated the right to health. But it runs coal mining operations, dumps waste into the water, making the water unsafe for its citizens, killing the marine life that is there, yet the citizens of Lindy Town depend on that for their food. Are you still convinced that the state has not violated the right to health?
Yes, Your Honor. We as a respondents maintain our stand that we've not violated this right. I will respond on this.
People are dying, they are having lung cancer, and you have the duty to refrain
refrain from violating rights.
And one of that, you are a majority shareholder of this coal mining company.
Thank you, Your Honors, for your question. In response to your questions, I invite this bench to look at the concept of sustainable development. The Constitution of NATO and other international instruments require that the state shall undertake development in an attempt to improve the quality of life of its citizens. We see this sustainable development has been adopted by NATO in the
Just made a submission. I'm trying to make sense. The Constitution of NATO under international instruments. Yes?
The Constitution of NATO and other international instruments.
Okay.
When you talk about development and relating it to the sustainable goals as well as those international instruments, is there an alternative economic activity that your government has taken other than the goals?
Thank you, Your Honor. In response to your question, I will base my response on Article 69 of the Constitution.
Is there an alternative economic development activity? Would they rather do farming, agriculture? What other alternatives are there?
Thank you, Your Honor. In response to your question, I will refer you to the control.
What other activity can be done?
If Your Honor may allow me to comprehensively answer that. The residents of Lindi have been saying before the activities of nature coal mining began that these people depended on fishing as the main source of livelihood. Your Honor, if I may proceed. But this fishing, we see Lindi town was a marginalized community. Marginalized communities are defined under Article 260 of the Constitution. That means these are communities which have been for various factors have been distanced from development, that is the socio-economic development of these other parts of the community. This, despite they had the fishing industry as the main source of livelihood, it was not adequate to advance the development. Your Honor, if I may proceed, yes, it could.
What if this marginalized community was an indigenous community protected under the UN United Nations Declaration of the Rights of Indigenous Persons? Would you then rightfully have mandated
I think, Your Honor, again we maintain our standard of respondents that the respondents have not violated this right. I will.
But country is also in the compromise that these fishermen used to fish at the shore, but as a result of the contamination by the water, they were forced to go to the high seas. And when they went to the high seas, it's dangerous, even boats capsized. And your government, or your plan, actually banned them from fishing in the high seas. So where do you want them to go? And you're killing them with cancer.
And if you contend that it was not, their traditional fishing, as stated in the discovery, was not economically viable, are you then killing the traditional knowledge of these communities that is international instruments to rely on its
I thank you for your question, Your Honor. I will first respond to the first. Just respond to all. I will base the fact that the government undertook coal mining. I will base this argument on the concept of impact assessment. Impact assessment has various stages. The fourth and the fifth being mitigation stage and continued monitoring and assessment. In paragraph 23, we see that paragraph 14 and 23, we see that reports have come up on the detrimental effect of the activities of nature coal mining on the residents of Lindi. These reports come. Nature coal mining has been operating for 4 years, but these claims have come after 2 years. Going back to environmental impact assessment, it is continuous based on the fifth stage. The fifth stage continuously takes the parties undertaking this activity back to the mitigation stage. If the mitigation stage, the initial impact assessment, if the mitigation stage, the measures taken to reduce the impact of this activity on the environment proves to be inadequate as it has in paragraph 23, that is the waste dumping mechanism, we're taken back to mitigation stage. And this we see in paragraph 27, the National Assembly Assembly of nature debated on these reports, the reports from the World Health Organization, the United Nations Environmental Programme, and Nature Agricultural Marine Institute on the negative impact of this activity. Upon this, the National Assembly acknowledged the fact that health hazards were expected from this by virtue of the nature coal mining activity. It further directed that the respective state authority responsible for this should undertake measures to ensure that the health and environmental rights of the people of Lindi are not further detrimented. This
mitigation you're talking about cannot be undertaken by ministries is a bit of a government, because mitigation is provided in the area, and the proponent, meaning the what parties doing the program, the person who was supposed to undertake mitigation. So how is it that can be done if you say that it is directed to a certain government?
Thank you, Your Honor. In response to your question, I will refer you to the statement of the facts, where we see that Nature Coal Mining Company is not solely owned by Local International. The state of Nature owns 52% of Nature Coal Mining Company. This means that they are the majority shareholders, and Local International owns 48%. The fact that the national government has directed a state agency to undertake measures to ensure that the rights are not further detrimental is pursuant to Article 27 of the Constitution, which in Section 1 says that citizens are entitled to equal protection of rights.
If you say that you have 52% shareholder and you are the government responsible to implement this, where do you strike the balance of economic activities in your application?
Thank you, Your Honor. The business of sustainable development, that is business within the constraints of human rights. Pardon?
Address my message.
Sustainable goals.
Respect to health.
Thank you, Your Honor. The Sustainable Development Goal of the United Nations number 3 states that it's concerned with reducing ambient pollution in a manner that ambient pollution is the right to environment and the right to health are indivisible, meaning you cannot achieve the right to health without achieving the right to environment. And this is when environmental impact assessment in the name of reducing ambient pollution comes in. And this we've seen, as I've stated earlier, that we have the mitigation and continued monitoring and assessment. If once measures are taken under the mitigation stage to reduce the impact of the negative impact of this activity, if later through continued monitoring and assessment reports come up showing that the previous measures taken are not adequate to reduce the impact of this, the parties conducting this activity are required to go back to mitigation stage. And this we see in paragraph 37 and 38, where the state has called the county government, Tendahaki were the applicants, and Nature Coal Mining Company to come to address the issues that are coming up based on the activities of nature coal mining.
So what does the government do to mitigate climate change?
Thank you, Your Honor. The government has, under the tripartite obligation of the state, that is Article 21(1) of the Constitution.
Answer your 2 minutes.
Thank you, Your Honor. The state has the obligation to protect, promote, and respect. Thank you, Your Honor. In response to that, I will say that the responsibility of the state to protect these rights is continuous. The government is not in the business of reacting to violation of rights. It's in the business of promoting, respecting, and upholding these rights. But then action can, pardon me, please.
No, please respond to the question.
The state is not in the business of reacting to human rights violations.
Pardon me if I may expound on that or use that statement. The duty of the state to protect the rights does not only come up when these rights are violated. It is continuous in that even before the rights are violated, the state is still obligated to protect these rights. But action on the violation of these rights can only be taken once they are violated, despite the fact that this responsibility is continuous.
You say the responsibility of the state does not extend to preventing violation of rights.
Pardon me, Your Honor. Thank you for your question, Your Honor.
You want me to Yes.
That is not my submission, Your Honor. Let me explain. I have stated previously in my submission that the responsibility of the state to protect these rights is continuous. It is not dependent on any other factors, whether these rights have been violated or not. The responsibility of the state provided in Article 27(6) still stands, but action pursuant to this article can only be taken once this right has been violated. That is why I use the word react. The government is obligated to protect these rights, not to react to the violation only, but to protect them and even prevent this violation. But in the event of this right being violated, the government is to take action.
And when you talk about government protecting these specific rights, we have the convention on rights of individuals. These are best talks about.
Address the courts on convention on violation in respect specifically to the marine environment. I am not privy to that convention by international institutions. That was not one of them. Has your country ratified the convention on diversity? Yes, Your Honor. By virtue of under Article 2(6) of the Constitution of Nature, all international instruments ratified by nature shall form part of the laws recognized by this Constitution. What about Number 4, 2016? Act Number 4, 2016. I am not privy to that ratification of international instruments. I seek indulgence that I am not privy to that.
I know, because are you saying that from the position, first of all, who do you represent?
I represent the first and second respondent, that is nature called mine.
So from your standpoint, do you agree that rights have been violated according to the circumstances that have been outlined before today, or do you disagree that rights have been?
Thank you, Your Honor. It is the submission of the respondents that the rights have not been violated, by virtue of the fact that these rights are realized progressively, and this is responded in Article 20.
The mere fact that rights are realized progressively means that they have not been violated.
Thank you, Your Honor. That is addressing the concept of limitation of rights. If Your Honor allows me, I'd like to answer that comprehensively.
You can say yes and then elaborate, or you can say no and then elaborate. I'm reacting. That's the mere fact that the rights have to be realized progressively means that they cannot be violated.
No.
So rights have been violated.
In this context, it's a submission they have not.
People have died. People have lung cancer. I don't understand. So how can you again say what has been contaminated? Fishermen can't fish where they fish anymore.
There are reports from the World Health Organization, from the UNED. I mean, these are institutions of no mean feat.
And this is a report that has been taken within 5 months.
Parliament has considered.
And this, the fact that people have died, there are safety issues, mistakes have happened, we expect this to happen.
Has the state taken any measures to conduct its own research?
Thank you, Your Honor. In response to all your questions, I will refer this honorable bench to Article 69F of the Constitution, which requires the state to set up systems of environmental impact assessment and management. The manifestation of this we've seen in the form of nature, agriculture, and marine research.
We've looked at that article. Please look at Article 70. So what case is now before us? In line with Article 17, what do you expect us to do?
Thank you, Your Honor. In response to your question, I will refer this bench to Article 24(1), which states that fundamental rights can only be limited within the constraints of the law, and even then it is to an extent that is justifiable and reasonable.
Precisely.
It's your submission that rights have been violated, but they are justifiable in the circumstances. Because if you direct us to Article 24, that is essentially what you say.
I think for your question, Your Honor.
So don't double speak. Rights have been violated, but that amounts to limitation and it's acceptable within Article 24.
Thank you for your questions, Your Honor. I will again base my response to those questions on the concept of sustainable development.
Counsel, thank you very much. You have not answered a single question you asked. Thank you.
Are you willing to go for alternative dispute resolution? Are you willing to go for alternative dispute resolution? The bench directs that you have an out of court settlement. Are you willing?
Yes, Your Honor. Thank you.
Which level are you willing?
We will seek a tribunal to address the plea.
Is that a meaning? Is that an alternative dispute resolution mechanism?
Maybe to ask, do you understand what alternative dispute resolution is?
Yes. There's other ways of resolving dispute that do not include court proceedings.
Example?
We can institute independent commissions such as those set up by the national.
Mediation. Is it mediation?
Direct yourself to 159 and peak amendment. Direct yourself to 159 1C and peak amendment.
Thank you, Counsel. We will look at that. For the second Counsel, please address us. You have strictly 7 minutes. Your colleague has not answered a single question. We've gone round and round. So I hope you'll be directed to precise.
Thank you. Thank you, Mr. President. Your leadership, as said by my co-counsel, my name is David Remain, appearing as second counsel for the first and the second respondent. I will use the 7 minutes at my disposal to comprehensively address issue 3, which before this court, which really is whether the respondents are liable for the enforced disappearance and extrajudicial killings of the 5 Kenyatta officials.
Just before you address, do you know anything about the blue economy?
Before I make my submissions, I shall respond to one question that I found to be quite direct that was asked by the leadership, that apart from fishing, whether there are other economic activities that are undertaken by the community in question. I shall invite the court to look at paragraph 20 and paragraph 21 of the fact pattern. Paragraph 20 speaks to the fact that the governor of Lindi County, in her annual report to the county assembly, stated that once the bridge project, and the bridge project, Your Honor, is being constructed from proceeds of the coal mining company, once that bridge project has been completed, the proceeds from the coal industry would expand markets for local cottage industries, expand economy. Paragraph 21 says that there was a potential to increase revenue from the tourism industry in Lindi by 2% upon completion of the bridge, since the bridge will then connect the island and the mainland.
So it is okay to build a bridge, establish a market, but violate the traditional cultural practices of the community.
Thank you, Madam President.
There's an economic right overriding culture to
thank you. I will not try to advantage. Thank you. Whenever they are conflicting against each other. Thank you, Mr. President. I will first begin by making it clear that it is not our submission that we should achieve this economic progress at the expense of fundamental human rights. While it is important to the state, as clearly claimed in Article 21, to protect the rights of its citizens, it is also the obligation of the state. The state actually owes its citizenry the right to development. The state should be proactive in every action that it takes to ensure that while the rights of the people are being protected, they are not being protected in poverty. That these people, while having their rights protected, would also have means to provide for themselves, because it was not
sustainable development bodies.
Thank you. I was quoting Article 21.
That is just the G goal number. Which of the 17 goals we have is the issue of property in this state?
I'm not able to cite the
G goal number 1.
Thank you. my submission here being that it is important for the state in protecting its citizens' rights to also make sure that these citizens are able to fend for themselves, because the state can protect them, but the state cannot provide for them. What the state can do is to provide means for them to provide for themselves, which is what paragraph 21 attests the state to have been doing. That having been said, the leaderships, I would then advance my arguments in making a case for the respondents in absolving them from blame in the interest of time, in one encompassing argument, that in making a case against the respondents, the applicants have largely relied on circumstantial evidence. In the second place, the applicants have submitted before this court that the state has not done anything in its power in connection with this matter. I shall begin with dealing with circumstantial evidence. The principles of circumstantial evidence have been held in various courts, both domestic and international, and there are 5 principles that are commonly held, 3 of which are very common, in what should constitute a case, a basis of conviction to be made on grounds of circumstantial evidence. I will quickly rush through them. The first one being that the circumstances from which the inference of guilt that is being made should be firmly established, and second, that the applicants have a duty before this court to prove that there has been a tendency which form part of this chain that points unerringly towards the respondent, and thirdly, that the chain formed by the applicant's case should be so complete that in no possible way can the respondents escape this chain. In light of these 3 principles, it is our submission as respondents that these principles have not been met in this case. In the first place, the 5 Kenyatta officials, 3 of which unfortunately are dead, attended a meeting that was called by the government. I would like us to look at the background of the calling of this meeting. The first council spoke about continuous assessment of in events that a company has been established and certain environmental detriments have occurred as a consequence of the same. That the government, as a result of continuously keeping abreast of circumstances in the coal mining company, called all the stakeholders to a meeting to discuss the effects that are coming from the establishment of the coal mining company. So it is important that we understand that this meeting only happened in the first place because the government was really following the procedures of an environmental impact assessment. So they were called to the meeting and they addressed various issues, and they...
Maybe one thing you address as you wind up is what the applicants are trying to point out, that you have had a history of very suspicious activity, not only towards your citizens, but also towards Tendahaki. Number one, there's evidence that there have been brutal beatings, burning of houses, individual houses. Number two, you have disowned all the other reports. Number three, you deregistered the applicant's organization. Yes, and because of tax compliance issues, only after they have said that they are bringing or issuing out a report on the coal mining. So those suspicious activities which occasionally led to the persons, 2 other people disappearing, 3 dead, others disappeared. Those suspicious circumstances, they are saying that they are too suspicious. You must be involved in the disappearance of these individuals. Please help us on that to delink, if you are at all delinking responsibility of your client from those actions as you wind up in the next 3 minutes.
Thank you, Mr. President. Indeed, the applicants have submitted that there is a history of conflict between the applicants Tendahaki and the government, the state. I would like to invite this guys to look at paragraph, that is paragraph 34 of the facts.
Tell us what it says.
Thank you, Mr. President. Well, this paragraph says that one Mr. Abdullahi, the applicants have largely relied on to make the case, claim that the people that burned down his house and the people that locked him and his family out of it, he suspects them to be operatives of the government. It is not stated that these were actually government operatives.
Yes, but leave alone that scenario. What about these other scenarios?
Mr. President,
including the registering the applicant's organization.
Thank you, Mr. President. Well, you see, in the statement of facts, it is pointed out that the state of Nigeria is a largely progressive nation. It is the fourth, it is ranked fourth in economic, in GDP, in the state of Kafri. This means that in order to provide for its citizens and in order to maintain that high standard, it requires resources. Part of the way which the government obtains its resources is by paying of taxes. If Tandahaki does not pay its taxes, how does it expect us to fulfill these obligations that it is fighting for?
But you're willing to reduce the taxes from foreign investment and in the rights of the workers.
Thank you, Your Worship. The fact that we reduced the taxes on foreign companies is in no way linked to the taxes that Tandahaki is supposed to pay. Yes? It is, and by reducing the taxes.
How much did Tandahaki owe you to the extent that you say, no, this is too much, let this go on. Let's register it.
Thank you, Mr. President. Well, I will begin by tackling the first issue, for reduction of taxes on foreign companies. You see, these foreign companies, when investing in projects such as the coal mining company, we're able to see that we have proceeds, and the proceeds that come from them investing then enable us to fulfill certain obligations to the people, like expanding the fishing industry, like as pointed out in paragraph 2.
Maybe also you're thinking yourself, how do you expand the fishing industry when the water is polluted? Fishermen can't fish on the shore, they have to go to the deep sea. The deep sea already banned them from going there because they do not have equipment sustain them there.
Thank you, Mr. President. There is a large the applicants have misled this court greatly, that when they wrote to the company on how it plans to change its waste management processes, I would invite this court to appreciate that waste management is not a small issue, and when you seek answers from when you seek answers from us on how we plan to change our waste management process, in order to comprehensively respond to that, the company would require time to compare its reports, to revisit its process.
How much time do you do that?
Mr. President, I will not in a position as counsel to.
But your full instructions to actually reply. As I said, they require. So we could give you administrative undertaking. That is what we do. So if you have that knowledge, then you can compute times.
You can clearly see, Mr. President, from the statement of facts, the amount of time that it took from the compilation of the first report to the compilation of the second report, and based on that, I would invite this court to appreciate that you need adequate time.
As you're speaking, look, Madam, what the time you need?
Mr. President, I believe that several months would be adequate to.
How many months exactly?
Minimum 3 months.
3 months.
To adequately.
So it is on record. 3 months. Thank you, Council. So the applicants, the applicants have their right to rebut 30 seconds. Don't submit on something you did not submit, something that was directly raised.
As earlier mentioned, my name is Rachel Wendo, and I'm here to rebut on behalf of the applicants. The respondents have raised that circumstantial evidence is not admissible. It is actually admissible. Furthermore, the black masked men were state actors, and coincidences do not happen in law. Thank you.
Thank you. Exercising my discretion, I will invite the respondents to do some rebuttals on whatever they raise for the next 30 seconds. Do you want to say that, right?
Yes,
please say something.
Thank you, Mr. President. In responding to the applicant, I would invite this court to mirror the judgment that was held in Maryland and Jurisdictional versus Republic, in which the court held that suspicion, however strong, cannot provide a basis for informing guilt. Thank you, Mr. President.
Thank you. The court takes this opportunity to thank counsels for the applicant petitioners and counsels for the respondents for your able submissions. We reserve our judgment. Matter stands adjourned. You can move at your own question. Thank you very much.
All right. Now.